Hello and welcome to Courts Today by Live Law. Let's get to today's top legal updates. No hanky-panky in SCBA polls, just counting error. Supreme Court clears air. Supreme Court refers to CJI Bangalore Palace TDR case. In the case of spying charges, Haryana YouTuber Jyoti Malhotra sent to judicial custody. Supreme Court to hear MBBS intern stipend case in July. Court slams Delhi police over weak probe in 2020 Kapil Mishra tweet FIR. Bombay High Court defense student arrested over Operation Sindoor post. She is now criminal. Woman judge moves Supreme Court after denial of childcare leave. Supreme Court rejects plea seeking ban on improper use of Savarkar's name. I'm your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end. And don't forget to like, share and subscribe to our channel because your support means the world to us. Live Law Premium subscription starts at just Rs 1099 plus GST. Subscribe now. The Supreme Court on May 27th heard challenges to the Supreme Court Bar Association 2025 election results. Senior advocates Adish Agarwala and Pradeep Rai, who lost the SCBA president post to senior advocate Vikas Singh, questioned vote count discrepancies. The court noted that a recent and recounted vote shows 75 fewer votes than the earlier declared votes, but this did not change the outcome. Justice Suryakant observed that it seemed like a genuine mistake, not foul play. The court rebuked Agarwala for making baseless allegations and recorded his unconditional apology. The bench also requested a recount for the 9 junior executive member posts to ensure transparency. Justice Kant praised the election committee, calling their conduct independent and fair. Complaints included claims of email campaigning and voter impersonation, which were found unsubstantiated. The court emphasized that such conduct shouldn't discourage honest members from taking up election duties. While dismissing calls for a re-election, the court directed Supreme Court staff support for recounts. Earlier, it had said serious election irregularities would be probed if backed by evidence. The matter relates to a long-running case on SCBA reforms. The next steps will depend on the outcome of the executive member recount. The Supreme Court today referred the Karnataka government's plea regarding the release of transferable development rights or TDR certificates to the heirs of the Mysuru royal family to Chief Justice of India B.R. Gavai for appropriate directions. This follows the May 22nd order by another Supreme Court bench, which directed Karnataka to issue TDR certificates for 15 acres of the Bangalore Palace Grounds acquired by the state. The current bench of Justices Suryakant and Dipankar Datta expressed difficulty in hearing a plea that could amount to sitting in appeal over a coordinate bench's decision. Senior advocate Kapil Mishra, representing the state, argued that the order was passed in a contempt case, whereas the current application is in a related appeal. He also said that TDR provisions were introduced only in 2004, so they shouldn't apply retrospectively. The Royal Family's Council countered that TDRs had already been granted, making the matter infructuous. The bench suggested placing the issue before the CJI for further instructions, including possibly forming a larger bench. The dispute traces back to the 1996 law acquiring Bangalore Palace Grounds, which has been under litigation since 1997. Jyoti Malhotra, a 33-year-old travel vlogger, was arrested on May 16th and has now been sent to 14 days of judicial custody by a Hisar court. Police claim she was in contact with Pakistani intelligence operatives and allegedly shared sensitive information. Malhotra is one of 12 people arrested across Punjab, Haryana and Uttar Pradesh in the past 2 weeks in connection with suspected espionage. She has been booked under Section 152 of the new Bharatiya Nyaya Sanhita for acts threatening India's sovereignty and unity. Her electronic devices have reportedly yielded 10 to 12 terabytes of data, which is currently being analyzed. While no official word is being released about her bank transactions, the police are reviewing her 4 bank accounts. Authorities also clarified that she neither had access to military or defense information, nor did she marry any Pakistani operative or convert her religion, contrary to current media claims. Central agencies are also now involved in questioning her. The Supreme Court will hear in July a plea challenging the non-payment of stipends to MBBS interns. The matter was mentioned before CJI B.R. Gavai, who said it would be listed before Justice Sudhanshu Dhulia's bench during July's partial working days. Petitioners' counsel highlighted that some interns are receiving no stipend at all. The court had earlier in April 2024 directed the National Medical Commission, or the NMC, to provide data on stipend payments across all medical colleges. The court observed that NMC had not fully complied with its order in September 2023, which required a tabulated chart on stipend status, particularly in light of claims that 70% of colleges either don't pay or pay less than the minimum stipend. A related case on the non-payment of stipends to foreign medical graduates is also pending. Additionally, another petition challenges the National Board of Examinations, or the NBE, decision to conduct NEET PG 2025 in 2 shifts. Petitioners argue this is unfair, as differing paper difficulty can impact rankings. They are demanding a single shift exam to ensure fairness. The court had earlier agreed to hear this matter in the last week of May, after it was mentioned on May 23rd. A Delhi court has criticized the Delhi police for its poor investigation into a 2020 FIR against BJP Minister Kapil Mishra over his controversial tweets during the Delhi Assembly elections. Mishra had tweeted that Shaheen Bagh had become a mini Pakistan and called the election battle between India and Pakistan. The additional Chief Metropolitan Magistrate ACMM Vaibhav Chaurasia noted that despite repeated directions since March 2023, no meaningful progress was made verifying Mishra's Twitter activity, and police failed to provide an adequate explanation. The judge highlighted that the police had earlier promised to seek data from Twitter, but no officer was present in court to report on the follow-up. The court has now informed the Commissioner and Joint Commissioner of Delhi Police about the matter and directed them to act. The judge added that if any central ministry's help is needed, the police should not hesitate. Mishra's legal challenges continue, with a trial court and a special judge previously rejecting his pleas. The next hearing is on July 7th. Mishra is accused of violating the Model Code of Conduct and promoting communal enmity during the 2020 elections. The Bombay High Court on May 27th strongly criticized the arrest and rustication of a 19-year-old engineering student over her Instagram post on Operation Sindoor. A bench of Justices Gauri Godse and Somashekar Sundaresan remarked that the student must be released, adding that she had already faced enough consequences, including being rusticated by her college. The court questioned the college's conduct, asking if educational institutions are meant to reform students or turn them into criminals. The judges emphasized that the student had apologized and clarified her intent and should be allowed to write her remaining exams. The student from Pune's Singhad Academy of Engineering was arrested on May 9th for reposting critical content about India's handling of Indo-Pak tensions. Though she deleted the post within hours and apologized, she was arrested after protests broke out and was rusticated without being given a chance to explain. The court disapproved of the state's suggestion to let her write her exams under police escort, saying she is not a criminal. The bench asked her lawyer to file a separate bail plea, assuring it would be heard immediately, and ordered authorities to assist in securing her release. A woman additional district judge has approached the Supreme Court challenging the denial of her childcare leave request. On Tuesday, her counsel mentioned the matter before a bench led by Chief Justice of India B.R. Gavai and Justice Augustine George Massey. The counsel informed the court that the judge is a single parent and had applied for childcare leave from June 10th to December. After being transferred to another location, the CJI asked why her request was rejected, and the counsel replied that no reason had been provided for the denial. The court was also informed that the judge belongs to the Jharkhand High Court jurisdiction. After hearing the brief submission, the Supreme Court agreed to list the matter for hearing soon. Childcare leave, especially for single parents, is crucial in ensuring both personal responsibilities and professional duties are managed effectively. On May 27th, the Supreme Court dismissed the petition seeking to include the name of VD Savarkar in the schedule of the Name and Emblems Prevention of Improper Use Act 1956. The plea was filed by petitioner Pankaj Phadnis, who appeared in person and claimed he had been researching Savarkar for years. He also alleged that leader of opposition Rahul Gandhi was violating fundamental duties by making comments against Savarkar. A bench of Chief Justice of India B.R. Gavai and Justice Augustine George Massey questioned Phadnis on how his fundamental rights were being violated. The court clarified that under Article 32 of the Constitution, only violations of fundamental rights can be challenged, not fundamental duties. The petitioner argued that such comments interfered with his ability to perform his fundamental duties under Article 51A, but the court found no merit in his claim. The bench advised that if Phadnis wanted changes in curriculum or any official recognition for Savarkar, he should approach the union government. Since no fundamental right was shown to be violated, the petition was dismissed. The court held that the relief sought cannot be granted under Article 32 of the Constitution of India.